Today's victory is not a win just for Breanna, Koski, and me. It's a victory for everyone.
One of the owners of Brush and Nib's studio declared a sweeping victory after the state Supreme Court ruled the city can't force them to make customized wedding invitations for gay couples. But that wasn't the reaction of the Phoenix mayor to the divided 4-3 court ruling.
The City of Phoenix's non-discrimination ordinance still stands.
Mayor Kate Gallego pointed out the ruling was limited to just one business and does not overturn the city's ordinance that protects gays, lesbians, and transgender from discrimination.
Today's decision is not a win, but it is not a loss.
But the LGBTQ activists raised concerns that today's decision could pave the way for similar lawsuits that will chip away at the city's anti-discrimination ordinance.
We have had multiple hits against this ordinance, and it has still stood. It's still standing now, but it is a problem. It will be. People will keep hitting it as long as there is not equality.
While the ruling itself says it applies only to Brush and Nib, an attorney for the Alliance Defending Freedom said it sets a much broader precedent.
It applies across the board to the LGBT artist, to a Muslim artist who can't celebrate Easter, to an atheist singer, to even news journalists, I think, would be protected.
As for where Phoenix goes from here, city officials tell me they're still looking at the issue right now to see if and how they could move forward on this if they chose to do so.
But Dennis, this only applies to invitations?
Yes, that is considered an artistic expression. They still have to sell like bulk items, like bulk thank you cards, wedding stuff like that. If they buy this stuff in bulk, they would still have to sell them to anybody who wanted them to. But they feel like these custom invitations to weddings, if a gay couple were to ask them to make that for them, it'd be an artistic expression, and they would be forced to celebrate or somehow support something that their religious beliefs tell them is wrong and they shouldn't support.
Quickly, Dennis, last time we talked about the state Supreme Court, it was Governor Doug Ducey appointing former County Attorney Bill Montgomery to the High Court. Was he a part of this ruling?
He was not a part of this ruling. He's only been on there about a week or so. So he was not. It was actually Justice Bales, who is now retired. He was part of this ruling. He actually was on part of the dissent of this 4-3 ruling. But he is now since retired. Probably his last dissent we're going to see from him, particularly in a big controversial case.
Interesting. Our political editor, Dennis Welch, thanks.